today, and many millions of people um, around the country are using Librium as a tranquilizer.
So,
Uh,
was that Leo Sternbach that made that? Who was the
Leo,
Leo
yeah, I
Sternbach?
said Marcel and I misspoke.
Yeah, so
It
it
was
was
it was Leo Sternbach,
okay,
right?
yeah. And if people look up Leo Sternbach, he invented literally hundreds of medications. You can look on New York Times, they have an article on him. So he was heavily involved in pretty much the industry that we have today. If you want to move your screen down a little bit, again, I know it gets habitual. I understand. Yeah, so if those that are watching, Leo Sternbach is pretty much the reason why we have what we have today regarding pharmaceuticals. And that's something I actually talked to Ralph about is my concerns with how much did Leo know regarding people getting injured versus not getting injured. But anyway, so Leo Sternbach was involved, and just strange coincidence, Ralph just so happened to be working in the lab, right? You were in the lab with Leo where these medications were first invented then, right?
I was when he hired me. The Librium product had recently been approved by the FDA, um, and at the time, he was working on modifying the Librium molecule and aiming to a product that became eventually patented and sold as Valium. And Valium is widely used today. In fact, it's the number one mind active drug that is used. Um, Neither uh, Librium nor Valium uh, are known for causing um, much harm. They don't cause tardive dyskinesia, um, as far as I'm aware.
So I'm
Uh,
actually going to stop you there for a moment. I was injured and developed akathisia from Ativan, which might have been one of the medications he invented. And so I developed akathisia and tardive dyskinesia, severe, like arguably one of the worst cases some people have ever witnessed. And I eventually switched to Valium and still have akathisia and tardive dyskinesia with the Valium. So there are some reports of benzodiazepines causing it, and if you look into their effect on GABA and dopamine, it sounds like they can deplete dopamine as well, which I could share resources regarding that. So people could Google um, benzodiazepine akathisia. And there's like it doesn't show the specifics of Valium and Librium, but it does show other benzos of reports of people developing akathisia from them. And so, from what I understand, they all pretty much work in this similar ways. It's just the metabolism is slightly different, and the amount of time that they last in the body is slightly different from what I know so far. So there are reports of benzodiazepines causing akathisia, myself being one of them that's developed the condition, and even Dr. Jordan Peterson, which a lot of people know. Dr. Jordan Peterson developed akathisia from taking as prescribed doses of a benzodiazepine, and that's why he disappeared for 1 to 2 years, maybe even longer. And he fled to Russia and was put into a coma to be treated for his akathisia and to get off the medication because he was struggling so badly at the hospitals in Canada and the U.S. to actually get the treatment he needed. And Michaela Peterson, his daughter, there's an emotional video of her getting really upset about how um, he just needed to get off the meds in his case, and eventually the akathisia went away. So benzodiazepines have been reported to cause akathisia in a lot of people. Anyway, so uh, yeah, so from talking to the Akathisia Alliance for Education and Research, I find it interesting that you so happen to be in the place where the benzodiazepines were invented, although hundreds. Um, the benzos were invented, and I also talked to the Akathisia Alliance on how Regland metoclopramide, as some people might know it as, also causes akathisia, but not only akathisia, tardive dyskinesia. And so it seems like some of the lawsuits that you've been involved in, or a lot of them, were involved in that medication as well. So anyway, I'll let you get back to what you were saying. I just wanted.
Sure. Um, and so with your comments, it is indeed so that Dr. Sonderborst
Uh, Leo,
um,
sorry.
ultimately created, I think, about 140 some different pharmaceutical products that the Hoffman LaRoche company patented and sold. They weren't all mind active drugs. Um, they're what they knew in the kind of testing that's available before a drug gets approved on the market um, did not reveal any extrapyramidal side effects to the Librium or the Valium. But that is the context of drug injuries and drug product liability litigation. Um, Many people do not realize this, but the FDA itself does not test drugs where drug companies are seeking the privilege of putting a drug on the market. The pharmaceutical industry is an industry intended to make a profit. They develop products where, in order to get approved, they have to show that there are benefits, and they have to show that the benefits outweigh the risks. Um, but then they have to adequately warn physicians so that the physicians in turn can warn their patients about the potential side effects of drugs, any drug, whether it's a mind active drug or any type of drug. The fact that a prescription is necessary uh, means that it's a product that is unavoidably unsafe. A prescription drug product cannot be used over the counter. You can only get it with the prescription of a physician, and that's because there are known and identified risks that could result in serious harm. And the concept of the civil justice system is that it's a organizational system that goes back to the time of the ancient Greeks, um, Plato, Socrates. Um, uh, Developed and wrote about the concept that all human beings have a duty to use reasonable care to prevent harming another human being. And the common law has developed in the United States where the judicial system of the United States, created with a three parts of the of our system. We have a legislative branch, a judicial branch, and an executive branch. And the judicial branch of the U.S. government, when it comes to civil liability, is based on the concept of negligence. We all have a duty to use reasonable care to avoid harming others if we didn't use reasonable care, and that can be demonstrated to a jury of your peers on a more likely than not basis. One need not establish proof beyond a reasonable doubt. Everyone in the country knows that former President Trump, Mr. Trump, is in a courtroom right now in a criminal trial, and that charge needs to be proved beyond a reasonable doubt with all types of judicial evidentiary requirements and a right to not have to, in the civil justice system, there are also many procedural rights to assure that that if you're injured and you bring a claim, you're entitled to a fair jury trial if there's evidence to show that more likely than not you were harmed by the wrongdoing of others. So, if someone goes through a stop sign, that's negligence. Reasonable care tells people that we should stop at stop signs. You go through a stop sign, you run into someone else's vehicle, you cause harm, you were negligent. So if it's more likely than not that you were negligent, that's the burden that is you need to prove, and you don't need to have a unanimous jury. What's needed is it might be 10 people out of a 12-person jury, or 7 people, or 5 people out of a 7-person jury. You could, in some jurisdictions, have even only a 3-person jury. But that will change from state to state. But the burden is a preponderance of the evidence rather than proof beyond a reasonable doubt for a majority of the jury, but you don't need a unanimous jury. So coming out of law school, I was had the good fortune of being chosen to law clerk for the Chief Justice of the Washington Supreme Court. And after completing that 1-year clerkship program and passing the bar, only a few years after I was a lawyer, did I have a client come with a healthcare problem, a woman who was rendered infertile and required to have a hysterectomy as a result of her use of what was known as the Dalkon Shield intrauterine device. Now, it turned out that the drug company that brought the Dalkon Shield to market in around 1969, actually, was the A.H. Robbins Company of Richmond, Virginia, and the Dalkon Shield was a defectively designed medical device. Like all intrauterine devices, it was a piece of plastic that was shaped, a thin piece of plastic that was shaped like a shield, and we can have a picture of it in later presentations. And that would be on a plastic inserter stick, and an obstetrician gynecologist would push that through a woman's cervix into the uterus where the inserter stick would be turned and they would pull the inserter stick down, but the piece of plastic would be left in the uterus, causing a mild irritation of the uterus lining, and that would prevent a fertilized egg from implanting in the uterus. But the concept of the intrauterine device was that a woman could prevent pregnancy until she and a partner were ready to have a child, and there was a tail string attached to that plastic shield that would go through the cervix and hang into the vaginal cavity. But the Dalcon Shield tail string was a multi-filament string with 200 to 400 very tiny thin fibers wrapped with a nylon sheath. And that left them open so that normal vaginal bacteria, which is normal and appropriate, that every woman has normal vaginal bacteria, but they don't cause infection in the vaginal area. But with the Dalcon Shield, they would wick up through that multi-filament tail string and become deposited in the uterus or in the fallopian tubes or on the woman's ovaries. And then infection